this is a stock, this is an SBR, this is an SBR, this is, and we had pictures, but the court says even that is ridiculous and arbitrary and capricious because we've got these photos that are determinative, but we have no explanation as to why. So it still doesn't help us. We are the arms attorneys. Today we are talking about the latest case to come down about pistol stabilizing braces. You might have thought we were done. We're not done. We've got a case that involves 25 different states' attorneys general, and I think creates a more interesting future for pistol braces and for ATF regulation. But before we get started, show your support for the Second Amendment by hitting the like button.
So by way of a little bit of background, we have a district court permanent vacatur of the final rule on factoring criteria for stabilizing braces. All right, that's a nationwide, effectively decriminalizing brace pistols. The government is trying to say, hey, guess what? These things transform your firearm into a short barrel rifle. Therefore, it would need to be registered under the National Firearms Act. You'd need to pay your tax stamp. You would need to get pre-authorization from us, the government, in order to carry one of these things, possess one of these things. Well, all right. We got that rule put on hold, but there are still pistol brace cases that are winding their way through the courts, and they could have, I would say, very significant impact on this entire discussion because the basis is just a little bit different. And I think a good way to illustrate this, we'll start with a standard. We'll go back to the Fifth Circuit, or it was a district court case in the Fifth Circuit, but we'll go back to that standard and kind of compare and contrast the two and talk about why these two things are so stinking important. But it starts with the arbitrary or capricious standard, and this is where federal appeals courts, they'll look at regulatory rulemaking. This is, even though this sounds a little bit different, it is part of the Administrative Procedures Act. But what the courts are going to look at are, is there a rational basis for this, change in the rule? Did the agency consider all the factors at hand, and did they adequately explain themselves in promulgating the rule? And that brings us to our case out of the 8th Circuit Court of Appeals. If you want to follow along, this is case number 23-3230. And what's going on with this guy?
Well, we have a challenge from like 25 different states to this pistol brace rule. And as Richard mentioned before, we're not doing it the way we did it here in Texas. And the way we did it in Texas was essentially the district court ruled that it violated the APA because it failed the logical outgrowth test. So when an agency makes a rule, they have to propose a rule, publish the proposed rule, leave time for notice and comment, and then finally publish the final rule before it can get entered into the Code of Federal Regulations. However, that proposed rule and the final rule have to be similar, right? The final rule has to be a logical outgrowth of the proposed rule. And so essentially what we said down here in Texas when that court worked its way through was that proposed rule, which had that wacky form with all of the criteria for what made a stabilizing brace, had nothing to do with the final rule, which had no such form and basically was like, well, we've got this list of factors that we've never seen before, and we're going to evaluate the factors, and then we're going to tell you.
How's it marketed? How do people in the community use it?
Exactly. And so the rule was vacated. It was essentially null and void to begin with, fines the court, rule vacated. However, Richard and I were concerned at the time and are still, frankly.
They left the door open.
They left the door open, right? Because, the ATF can just go propose a new rule that looks just like the final rule they want to impose, and then impose that final rule. And then here we are back in the same world, but not with what we have in the 8th Circuit, which is what makes it so interesting.
Yeah, so if they would have just taken the final rule as is, gone back through the system, well, guess what? They wouldn't have failed the logical outgrowth test. And theoretically, we would have to find some other reason for, hey, this not to withstand judicial scrutiny. The 8th Circuit here does a little bit of that for us. It doesn't go all the way, man. They really they cut themselves off just a little bit too short. But this is what they do. They look at the arbitrary and capricious standard.
Yes, and that's actually what the exciting part about it and why this is important is that what we know from the 8th Circuit now is that the ATF cannot go back and just propose what's now the final rule as that rule because The Eighth Circuit is telling us that rule is arbitrary and capricious. And they do a good job of sort of knocking down different bits of the rule. For example, all of the what makes a rearward stabilizing brace able to be shouldered, that makes zero logical sense. And the Eighth Circuit does a good job of saying, look, this rule doesn't do enough to tell us what that means. What surface area is shoulderable versus not? Because remember, we had all those debates about like,
Yeah.
what if it's a blade? What if it's a blah, blah, blah?
What if you comes factory stock with Velcro that's tightened very tightly?
Right. I mean, it was just, why is a buffer tube not surface area? We just didn't know. We
Right.
didn't know the answers, right? And we didn't know what they were ultimately going to say about anything. And so we've got that arbitrary and capriciousness. We've got the arbitrary and capriciousness of the marketing and community factors.
Yeah. God, how dumb is that?
Well, and that I thought was really interesting too, because the court looks at it and says, look, not only does this not make sense, and the way it's, we don't know exactly what they're going to look to or to whom they're going to look. So, and this is really interesting because essentially the court's saying, look, the ATF says when they're evaluating this factor that a single individual in isolated circumstances doesn't matter, right? I mean, it's more than that. It's bigger than that. However, sometimes a single individual in isolated circumstances does matter.
Exactly.
We're looking
right.
at intent, then it does matter.
Sounds like the new purchase rules and sale rules.
Right, exactly. So, I mean, the court actually is pretty clear about that they are internally inconsistent and fail to provide an intelligible explanation and amount to a failure to engage in reasoned decision making. Ouch.
The ATF? You don't say.
I know, ouch. So, and then, we actually have then another note because remember, and actually, I thought this was the most helpful part of the final rule when it came down was that slideshow.
Oh, yeah. Where
Yeah.
it said that, the factory stock,
Yeah.
receiver extension.
Yeah. This is a stock. This is an SBR. This is an SBR. This is, and we had pictures, but the court says even that is ridiculous and arbitrary and capricious because
Right.
we've got these photos that are determinative, but we have no explanation as to why. So it still doesn't help us.
Yeah, and so, what's going on here? So we have the district court, they denied the coalition their preliminary injunction to stop the rule from going into effect. The Eighth Circuit is sending it back down with instructions to evaluate, basically that injunction again, following the instructions of the court here. But they go just a little bit short, and this is where I still think there is room for danger here because, all right, we've knocked out the argument that this violates the Administrative Procedures Act, logical outgrowth test. All right, well, now we're looking at arbitrary and capricious. Well, if the ATF goes in and I guess really reasons their brains out and tries to justify their actions, then maybe it would survive this challenge out of the Eighth Circuit. And there was one more kind of factor that they were considering here that the court declined to look at, and that was this within the scope of the ATF to even regulate? And they do not cite the Loper Bright Enterprises case. That's the case that shut down Chevron deference. It takes away, basically agencies deciding on what rules they get to promulgate, and they're given kind of the benefit of the doubt, and it takes Chevron took the authority away from the courts to kind of second guess these agencies' rulemaking. It declined to address the issue of, is this within the scope? Is this something that the Congress has delegated to the ATF to even regulate?
Right, which is unfortunate, but not surprising.
But that would have been a silver bullet.
It would have been a silver bullet. But how frequently do we get silver bullets?
Rare.
Rarely. And then sometimes we get them in the form of New York State Rifle and Pistol Association versus Bruin, and then they are not applied faithfully. So,
Yeah.
not surprising, although disappointing.
But I mean, question. We have the decision out of it's up in the Fifth Circuit right now. We have this decision in the Eighth Circuit. So I mean, we're kind of getting the same outcome based on different decisions. Do you see this kind of thing going to the Supreme Court?
No, I really don't, because we don't have a split. We have a little bit of like mild inconsistency just in reasoning and application, but I don't think it's enough. I mean, the Supreme Court's got kind of a lot to do.
Yeah, and the other thing I'd say is ultimately, for the foreseeable future, do I see braces being regulated as stocks and short-barreled rifles? No. All right, so we can don't hit the panic button just yet, but you see how the ATF potentially has some avenues here. Going back through the rulemaking process, if they reason it properly enough, well, guess what? They're going to satisfy the Eighth Circuit. They go back and republish the rule and just push it through a logical outgrowth. They'll survive the Fifth Circuit. So I will say this is not the end of the story when it comes to braces.
It is not, but it is for a little while. How about that?
But we hope you enjoyed this discussion. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm by sharing this video.
And don't miss us every Monday, Wednesday, Friday at 5 p.m. Central. Until next time, we're the arms attorneys.